end of that.
Yes, it is.
Because effectively you may have an organisation that can employ every means possible to prove their point, and you have less defence to be able to say that they did otherwise.
I mean, what you're putting your finger on there is the whole problem of employment law, which is the which is the inherent imbalance between the individual and the organisation. It's not always that way round, that imbalance. Certainly from the tribunal cases I've seen in Jersey, very often you're dealing with very small businesses who are worried by whether they are doing enough to comply with this law or not. Or you've got individuals who are represented by their trade union who might be quite well empowered, if you like, and the employer isn't in that position. The tribunal does its best, and I know the Jersey Tribunal quite well, and the tribunal does its best to equalise that power in the tribunal room. So it understands that if you've got an employer here with, 3 advocates and a bunch of lawyers sitting behind taking notes, and you've got a claimant in person here, they bend over backwards to make sure that there is equality between them. In fact, it's part of the overriding objective of the employment tribunal that it ensures the equality, that both parties are on an equal footing. And I know that the chairs of the tribunal take that very seriously. It's something that many employers have complained about, in fact, just how seriously they take it.
Can I just, before I lose the plot, is it part of your talk to, for example, under Social Security law, there's this concept of loss of faculty for LTI claim. Is it under these definitions inevitable that anybody who's got an LTI award will be termed as a disabled person? Is that an inevitable consequence of this?
I would think it would be, but the law doesn't specifically draft that.
Right.
So it doesn't say that anybody is going to be deemed to be disabled purely as a result of a Social Security assessment. I would think that, I find it inconceivable to think how someone could get that assessment without also meeting this definition. I just don't see a practical example of how that could be. But I don't think it's formally written. I mean, it's certainly not formally written to the regulations.
Because that is linked under Social Security law to the ability to work, even though loss of faculty isn't supposed to be, but the two are linked. So if somebody said, well, I'm disabled, I can't work, and Social Security said, well, you're not sufficiently disabled, on that sort of argument, which will come up under employment tribunals, presumably.
Yes, I mean, what I would encourage is that we don't get too bogged down in assessing people in advance as to whether they qualify or don't qualify. I think this needs to be a more flexible right than that, because otherwise you create this sort of bar that people have to clear before they've got a right not to be discriminated against. And I don't think discrimination works that way. I think very often that discrimination is what's contributing to the idea that you're disabled. And I think if you're being discriminated against, we should err on the side of that being illegal. There's a separate thing about your entitlement to certain social security benefits, which I think this law should steer clear of. And I think if you muddle the two, I think you're potentially in dangerous water. Yeah.
Could I ask, will the guidance, rather than the regulation, I don't think it's in the regulation, will the guidance advise on who is competent to do the assessments? I mentioned that in the context of a backlog we had over the long-term care law, getting assessments done, for example. But also, will it be GPs, will it be a social worker, or will it be self-assessment?
It is ultimately a legal question. So whether someone is disabled within the meaning of these regulations is going to have to be a legal question. That means that the only way of formally classifying somebody is to have a tribunal case to have that decided. The idea of having some pre-qualification, I think, would just create what we call satellite litigation, where what happens is someone thinks they're being discriminated against by their employer. The employer says, but this doctor, this GP, this separate body has deemed you not to be disabled. Well, then you end up having to challenge that doctor, that body, and look at the way in which they've carried out that assessment, whether that's correct or not. And there's no mechanism that we've got in the system to allow that to happen. So I think the only way to really make it work is to have the tribunal make the decision. What you want is to have as much clarity in the definition that employers will be able to be reasonably confident about what the outcome would be. The way we've set the definition, I think there are fewer technical traps than there are in the UK system. So it'll be harder for an employer to say this person is simply not disabled. So I don't see that as being a fundamental problem. I think we'll be better off with the tribunal deciding. And that's what the tribunal does when it's, deciding any right that's put in front of it. It has to decide whether the person who's claiming the right has the right to claim it.
Just to point out very early to you, but most charities and most corporates would do anything they possibly can to avoid going to a tribunal. And that would include seeking advice on whether somebody's disabled or not, or what's later on will come up with, but what is a reasonable adjustment to make and so on. And you're saying actually you won't find out until you go to
Well, I'm saying that you can take advice from all sorts of people. Jacks, I'm sure, will give advice to employers. Citizens Advice Bureau will give advice to others. There might be other bodies who will set themselves up. Lawyers, advisors, consultants will set themselves up advising people. But what you can't do is have a classification. So you can't say, well, because occupational health, for example, has said I am disabled, therefore for legal purposes I am. Because what happens if occupational health mistakenly says you're not? Right, so it's important that people are able to go to the tribunal and claim this right without having that blocked by a non-judicial body. Because I just think that creates, well, potentially all sorts of problems. Advice, there will be aplenty. But what there can't be is a preliminary ruling that forestalls what the tribunal says. Because ultimately this is about determining people's rights, and people are entitled to have their rights determined by a proper judicial process. Yes?
Presumably, you don't necessarily have to get to tribunal.
No.
So you could actually have all of that conversation going on outside of a tribunal.
Yes.
The legality is about definition, whether you have any of those things which would, just as one or additional
Well,
ones.
the legality comes when someone believes they've been discriminated against,
Right.
fails to get satisfaction through informal means, and feels that they need to validate their rights in law. They need to go to the tribunal process and get the compensation that they're due, or a declaration, or whatever it is that they're seeking. So there's all sorts of informal things that you would do, but ultimately it's for the individual who believes they've been discriminated against to assert their right in the tribunal.
So what happens before you get to the tribunal? Because in my head, we've jumped from reasonable adjustments, definitions, whatever, to a tribunal because you haven't done something.
Yes.
But surely there's a lot of stuff that happens before then for this law to actually be embedded somehow in the culture of Jersey that then enables you not to be discriminated or using discriminatory practice through ignorance or through deliberate means.
Well, I think it's inevitable that when what you're doing is giving people rights under a law, you have to describe how they pursue those rights. And then, if you like, you work backwards from now that they've got this right, how do we make sure that they don't need to go to the tribunal? How can we make sure that we don't get ourselves in trouble? I've certainly found from my experience, nothing focuses the mind of a potential discriminator like the prospect that they could get sued if they get this wrong. Right? You can spend quite a lot of time trying to voluntarily get people to go along with the idea of not discriminating against people. But it really does help to say, and if you get this wrong, you get sued. Here is how much you can end up having to pay. So if you want to prompt employers to make sure that they consider reasonable adjustments before taking particular steps, if you want to prompt people who are providing services to think about how those services impact on disabled people, you do need a bit of a stick. Because otherwise it just becomes awfully well-meaning and good practicey, but there isn't any bite to it. And my experience is it needs a bit of bite.
Oh, I agree.
Anything else on those points?
Yeah. So,
Sorry, yes.
coming back to your point about a blind person having a guide dog being refused.
Yes.
Yeah. who would we be protected by then as a, you know, a future guide dog owner? I'm on the waiting list for one, and I've had a lot of issues with, you know, people being refused. So will that affect employers, plus also anybody who has, you know, somewhere where you want to go, but you can't go because you need the guide dog to take you? So who would protect us?
I don't think that this law would specifically provide a right to provision from whoever it is that provides that sort of thing. But I use guide dog purely as a common example of the kind of discrimination where it's not so much the disability but something that might be associated with it. It could be lots of other things as well. And of course the duty that an employer has towards somebody, you take the disabled person as you find them. So an employer couldn't say, oh, it's not our fault, you just need to get a guide dog and that's not our problem. And a restaurant couldn't say that. They would have to make the reasonable adjustments that were appropriate given the situation that the individual is in, irrespective of what particular aids they had. In terms of whose duty it is to provide those aids, I think that's a separate area. It's not something that crops up in the context of discrimination, I think. Yes?
But then what would happen if a person had a disability which could reasonably be corrected by I'm thinking of a cataract.
Yes.
If I developed a cataract, I was employed, and I wanted to sit at home and say to my boss, I can't work on the screens anymore, and I refused an operation to correct the cataract and remove the cataract.
Yes.
Would I be regarded as disabled?
I think you certainly would be regarded as disabled. I think if we start saying, well, you should have done something about that, so you're not disabled, it takes you on a slippery slope down all sorts of, unpleasant alleys, if that's not a terribly mixed metaphor.
Okay.
But I think that's certainly problematic if you start saying people who are to blame are not going to be disabled. What it might affect, though, is the view that the tribunal takes if it gets to a tribunal. So there are two ways in which the employer might have to deal with that. The employer isn't treating someone less favourably because of their eyesight, it's because of their ability to operate the screen. So that puts us in the realm of something that the employer can justify if necessary. There's a duty to make reasonable adjustments. So the employer might, for example, typically someone who was blind or had a level of visual impairment, a reasonable adjustment might be to provide a braille reader, it might be to provide voice recognition software. There are all sorts of adjustments that can be made in the context of the screen. Now that has a cost attached to it, and so the question would be, how much cost does the employer have to bear? I think it would be a very good argument to go to the tribunal and say, ordinarily we'd be happy to pay X hundred, X thousand pounds in order to accommodate somebody, but this person can just have a cataracts operation. So is it really reasonable to impose on us this burden to make this adjustment if this person isn't doing their part by dealing with the condition that they've got? And I think that's an argument that the tribunal could hear in deciding whether the employer had done what is reasonable to make a reasonable adjustment. Does that make sense? So I think the answer to a lot of these issues is not the initial classification, are you disabled or are you not disabled? The answer comes, what does the employer stroke business provider, service provider have to do given the situation? And I think that's where a lot of those things are resolved. I was going to say, do we need to...
Can I just interject one thing?
Yes.
You do need to move on because obviously time will be pressing against me. There is in the consultation document picking up on the theory about the sort of step between complaint and going to the tribunal. Because very clearly said that there was employment that Jacks can consider it if there is an opportunity to do that. And if it's related to a non-employment matter, we use the community mediation service.
Yeah.
Is that the comment?
Yes, so absolutely. In all of these things, in the employment law and in the discrimination law as well, there is a lot of alternative dispute resolution that goes on before you find yourself in the employment tribunal. I don't know what the percentage for Jacks is of the number of cases resolved without going to the tribunal, but it's probably 50%, if not more, if not higher. I think you actually do a better job in Jersey than you do in the UK, because you've got a particularly good personal service in Jersey, where, you know, ACAS is a bit faceless in the UK, to be honest. So yeah, didn't
Where
have
it's
that.
not employment, where it's the use of services like restaurants,
Yeah.
and which aren't accessible, they got steps or narrow doors. I mean, obviously, if you make alterations to a building, you have to adapt them. If you carry out alterations, they have to comply. But if you're not carrying out alterations, it would be a bit onerous on an old building to have it altered in
Well-
order to accommodate people who might pass by.
I think that's one of the fundamental things that we need to take views on in the consultation. It's one of the consultation questions. There's a lot that can be done in terms of tackling disability discrimination that doesn't involve physical alterations to premises. The physical alterations to premises, particularly in a place like St Helier, literally walking around the streets, I can see issues. And I'm not necessarily the most aware of these things. That it strikes me are going to be tricky to deal with. I think it's very important that we don't let that stop what we can do in terms of discrimination law from going ahead. What the consultation proposes is that when it comes to the physical alteration of premises, there will be a 2-year implementation period. Implementation periods are problematic at the moment because everyone's talking about 2-year implementation periods or transition period.
Well,
At least in this case, we do know what we're transitioning to. A 2-year transition period where people who need to make physical adjustments to premises can do that. There is a separate issue that I think might have to be looked at separately around listed building status and historic buildings where it's simply not possible to do that. We need to look at what people think. And part of this consultation is very much to hear what people think about physical alterations. What kind of timetable is reasonable? Are there further exceptions that we need to think of in terms of the kinds of business, kinds of employer who won't be able to make physical adjustments to premises? And I know that that's something we'll be discussing in meetings over the next few weeks in advance of the consultation ending. But at the moment, the way that the regulations are drafted, there is a 2-year period. So the duty to make adjustments to physical features of premises will kick in from the 1st September 2020. Now, even then, it's only reasonable adjustments. So it will always be open to whoever is operating the premises to say, but you can't expect us to do that. Look at the size of our business, look at the resources we've got, look at the impact that this will have. It wouldn't be reasonable to ask us to spend £200,000 on this particular system for opening doors automatically. There may be a better way that they can achieve the same sort of thing. But I think that's one of the crucial things that we need to try and get sorted out over the consultation period. I know you've got other things you need to discuss in the meeting, so I can obviously talk for several hours about this and other aspects of disability discrimination. I'm sure I will. There are public meetings that are taking place tomorrow and also next week, and I'm sure there'll be other opportunities to feed in as well. So I would encourage everybody to feed in what they can. And I imagine we'll be talking to scrutiny as well over the course of that process. So there's a lot more work that needs to be done to make sure that we've got this the right way. Thank you for your contribution, and hopefully you'll see the results of that in a beautifully clear definition of disability, and you'll look at that and go, yeah, that was my suggestion, I sorted that out. So thank you very much for that. Any further questions or thoughts? Yes?
Guy raised the issue we mentioned earlier, that my concern would be where will charities go to work out what are reasonable adjustments in the circumstances, because most charities don't have an HR function. So apart from going to Jack's perhaps, and they may be operating in rented buildings, for example, but most of them will say, where do I start? I mean, I think we're okay, but are we okay? And I understand there's not resource actually being put into this to say somebody could do an audit for you, or we will license somebody or regulate the auditors to come and do an audit on your disability work practice to make sure you're compliant.
Yes, I mean, there will be lots of people giving advice. I think the difficulty is when we're looking at drafting the law, I don't think there's any way of incorporating that, because what you don't want is to make someone else's view binding on the tribunal. One of the things that I've certainly learned over the years looking at disability discrimination cases as they come through the UK system is there is no way of just listing reasonable adjustments, right? The variety of adjustments that you see tribunals coming up with would absolutely defy anybody who was operating a sort of checklist, right? You can't just have you got a ramp, have you got an automatic door, have you got, you know, a wider corridor? When you're dealing with disabilities like dyslexia, dyspraxia, anxiety, phobias, all sorts of things, there is absolutely no limit to what can crop up as a reasonable adjustment. So anyone you go to advice for is going to hedge it. Right? They're going to say, well, here's some stuff I've thought of, but they're not going to say, if you do this, you'll be fine. They're going to be saying, if you do this, I'm reasonably confident that you'll have a 60% chance of success. Because that's what we end up doing in the UK. Ultimately, people have to make their decision about how far they're prepared to go and put it in front of the tribunal if it needs to go in front of the tribunal. That's just how these things have to work, I think. Anything else that I can help with? Yes?
Sorry, if anybody, there was a good case last week, UK case on HR member.
Oh, excellent.
HMRC, at a tribunal, they lost a tribunal for not making a reasonable adjustment for a lady who had depression. She had been off for some time, and then she came back and her team was being relocated, and she was forced to move, and HMRC lost on that because they said that.
Yeah, £75,000, I believe she got.
That was £75,000.
I did read that one.
Yes, focuses the mind.
Yes, the maximum you can get in Jersey is £10,000 on the current law, but in the UK she got £75,000. I have to say I have some sympathy with the employer in that particular case. That's when you read the judgment.
Yes.
There were some difficulties with that particular claimant who refused to move desk, and there was an argument that she was claiming the benefit of disability discrimination to actually insist on sitting next to her friend. But that's a complicated factual scenario that might well play out in the Employment Appeal Tribunal, I'd suggest, having read it. It's a very interesting case. Focuses the mind is exactly right. They could certainly have handled it more sensitively.
Okay, thanks.
Yes, thank you very much.
I mean,